Hello friends, today let us discuss one case which was in Supreme Court, and the Supreme Court on 6th of November 24 gave a ruling, and the case was filed by the Enforcement Directorate. We call it as ED. So this Directorate of Enforcement is a law enforcement agency, as we all know. And another responsibility with ED is this is an economic intelligence agency. This ED is responsible for enforcing economic laws and secondly fighting economic crimes in India. And this ED has been in great talk, debate and discussion since last few years for the raids and cases filed by this ED against public servants, against politicians, businessmen and industrialists. In one such case, the Supreme Court has given a landmark ruling providing a shield, a cover to the public servants, and at the same time making the job of ED somewhat time consuming and difficult. Let us see the case and the ruling of Supreme Court. The case starts with ED filing complaints against two public servants. One was Mr. Acharya and the other one was Mr. Das. And the cases were filed under Prevention of Money Laundering Act. Who were these two public servants? Mr. Das is an IAS officer in Andhra Pradesh. Similarly, Mr. Acharya, he is also an IAS officer in Andhra Pradesh. Mr. Das was the principal secretary of a department in the state government, and ED claimed that he, with the conspiracy with the Chief Minister Mr. Jagmohan Reddy, extended favors to India Cement Limited by allotting an additional 10 lakh liters of water from a river by violating the norms. This was the charge against him. The charge against Mr. Acharya, who was the IAS officer in Andhra Pradesh, the charge was in conspiracy with the Chief Minister, Mr. Jagmohan Reddy. Mr. Acharya allotted 250 acres of land for the SEZ to Hindu Tech Zone Private Limited by violating the norms. And ED further accused both of them for indirect involvement in money laundering. With these two charges, the special court took cognizance of this complaint and issued the summons to these two public servants. When the summons were issued, both of them filed writ petitions against in the High Court, challenging the cognizance taken by the trial court. And they prayed to quash the complaints. What was the ground for this prayer? The ground was that both of them were public servants and therefore they claimed that it was necessary to obtain prior sanction under subsection 1 of section 197 of CRPC. The High Court upheld the respondents' contentions and quashed the orders of taking cognizance passed by the special court on the complaints. In short, what happened? ED filed a complaint. The special court took cognizance of it, issued summons. Then these two public servants went to High Court and High Court squashed it on the ground that no prior sanction of the government was taken. Against this order of High Court, ED moved the Supreme Court, and the Supreme Court gave the ruling, and for the very first time mandated that the ED has to take the prior permission to prosecute public servants on money laundering charges. Actually, Supreme Court upheld the Telangana High Court order and reasoned that Prevention of Money Laundering Act provisions align with CRPC requirements, and hence if CRPC is compelling the prior sanction before prosecution, naturally Prevention of Money Laundering Act cannot overrule that and cannot go to the court without taking prior sanction. So both of them could get the relief from the Supreme Court. Now what are the implications of this? Basically CRPC section 197 requires that the accused must be a public servant, and secondly, he must have done that act which his official duty requires him to discharge. These are the true conditions for getting prior sanction for prosecution. In the present case, the Supreme Court noted that both the respondents, Mr. Acharya and Mr. Das, were public servants, and secondly, they were empowered to do the acts that they have done. So there is a connection between their duties and the acts complained of. Hence, both the conditions of applicability of 197(1) of CRPC stood satisfied. Further, the Supreme Court says that the Prevention of Money Laundering Act does not supersede the requirements of Section 197 of CRPC. Thus, it is made very clear that the limits of Prevention of Money Laundering Act cannot override the authority of CRPC. Now, what are the implications of this? So far, ED was following the procedure as per Prevention of Money Laundering Act. But the provisions now with this ruling will have to be reviewed again. Now this ruling protects public servants, public officials, while performing their official duties. If they are doing it in good faith, then this provision now provides shield to them, cover to them, and now the court has created a check against arbitrary or politically motivated prosecutions of public servants without the government sanction. So this is one impact, one good shield provided to public servants. If we look at from ED's point of view, then we find that this judgment limits ED's ability now to prosecute public servants under Prevention of Money Laundering Act without the government consent, and that is, they will have to now complete the due process. Of course, investigation made by ED, they remain valid as per Prevention of Money Laundering Act. But trial courts cannot take cognizance of the charge sheets against the public servants without prior sanctions. And this is possible for public servants, and convictions can be overturned on appeal if the prior sanction is not taken. Public servants can raise this argument at any stage of trial, even after their conviction. This is the implication of Supreme Court ruling. Now, effect of this? I think Now ED will have to take the prior sanction of the government before filing a case, before moving the court. And we know, if we take this case only, as ED claims that both Mr. Acharya and Mr. Das, they have done some act, and that act has been done, as is claimed by ED, in conspiracy with the Chief Minister. Now if Chief Minister is involved, as is claimed by ED, how the ED can get the sanction from the state government? So it will become very difficult on the part of ED now to get the sanction of the state government in such cases. Of course, prior sanction is required either of state government or central government, depending upon the public servant's place of employment. If he is employed at state government's permission is needed, and if he is a central government employee, then central government's prior sanction is required. In short, it becomes very difficult for ED, in my opinion, to get the prior sanction if the politicians, if the ruling party, if the Chief Minister or any other minister is involved in such cases. Quite often, a nexus is found with politicians and the public servants. Immediate effect of this is high-profile figures like Kejriwal, like Chidambaram, in case of, as we know, Aircel Maxis case. Now such people are leveraging this provision to contest trial proceedings. So this is the effect for ED. No doubt it has given a shield to the public servants for the politically motivated actions, but at the same time it has created some roadblock for ED also. Hence one can say that there is a possibility that ED may become a lion with no teeth. Thank you. That's all.